Every county in America keeps a list. It is usually public record, it is usually searchable, and if your property taxes fall behind, your name and address land on it, often well before you would think to worry about actually losing your home. That list is real, it is not some secret surveillance program, and after this year's Supreme Court ruling in Pung versus Isabella County, understanding exactly how it works and exactly when your name moves from that list toward an actual foreclosure matters more than it did a year ago. Let's walk through how this actually works county by county and what you can do if you are anywhere on that pipeline right now. Quick thing before we get into it. I trace how a Supreme Court ruling actually changes the practical stakes of an ordinary, everyday government process, not just the abstract legal theory. If that is useful, subscribe and turn on the bell. 2 seconds, and let's get into how a delinquent tax list actually works. Here is the basic mechanism, and it works broadly similarly across most of the country, even though the specific timelines and terminology vary state by state. When a property tax payment is missed, it does not immediately trigger foreclosure. It triggers a delinquency notice and the start of penalties and interest accruing on the unpaid balance. If the debt remains unpaid, the property typically gets added to a formal delinquent tax roll, a public record maintained by the county treasurer or tax collector, sometimes published in a local newspaper as required by state law, sometimes searchable directly through a county website. This list is not itself a foreclosure notice, it is more like a formal, recorded flag that a specific parcel owes back taxes, and it usually comes with a redemption period attached, a window of time, often 1 to 3 years depending on the state, during which the owner can pay off the debt, penalties, and interest to clear the record entirely and avoid losing the property. The Pung family's own case, the one that reached the Supreme Court this year, is a useful real-world illustration of exactly how far this process can travel from a genuinely small starting point. Their Michigan home, originally purchased decades ago and long enrolled in the state's principal residence exemption, ended up foreclosed over a tax debt that started small and ballooned to $2,242 once interest and penalties accumulated on a home the county's own assessor valued at $194,400. That escalation, a modest original debt growing through interest and penalties into something that eventually justifies losing the entire property, is exactly the pattern the delinquent tax list is designed to track and eventually act on if it goes unaddressed long enough. Now here is why the Supreme Court's ruling this year genuinely raises the stakes of understanding your own status on this exact list, rather than just being an interesting legal footnote. In Pung versus Isabella County, decided 9-0 on June 23, 2026, the court ruled that when a foreclosed property is sold at a tax auction, the surplus a homeowner is owed above their tax debt is measured against the actual auction price, not the property's true fair market value. Since tax auctions frequently sell properties for considerably less than open market value, sometimes, as in the Pung family's own case, for a fraction of the assessed value, this ruling means the financial safety net waiting for you if your home does get foreclosed and sold is now smaller than many people assumed, based on the court's earlier, more homeowner-favorable ruling in 2023's Tyler versus Hennepin County. In plain terms, prevention is now worth meaningfully more than it already was, because the recovery available to you after the fact has just gotten smaller. So here is exactly how to find your own status and what to do at each stage, because the specific action available to you depends heavily on exactly where you are in this pipeline. If you are not sure whether you are current on your property taxes, your county treasurer or tax collector's office, not a private company advertising tax relief services, maintains the actual, authoritative record. And most counties now offer a free online parcel search where you can check your own specific status directly using your address or parcel number. If you discover you are behind, contact that same office directly and ask specifically about payment plan options. Most counties offer some form of installment arrangement to bring a delinquent account current over time rather than requiring the full balance at once. And many states and counties also offer targeted assistance programs for seniors, disabled homeowners, or those facing temporary financial hardship, programs that are frequently underused simply because homeowners do not know to ask about them. If your property has already progressed to the formal delinquent tax roll, understand your state's specific redemption period, the window during which you can still pay off the debt and fully reclaim clear title, and treat that deadline as a hard, non-negotiable date rather than something to address later. Since missing it is generally what actually triggers the foreclosure and auction process this entire discussion has been building toward. There is a specific, less obvious detail worth knowing about that list beyond your own personal status, and it connects directly to a scam pattern that has grown alongside increased public awareness of exactly this legal area. Because delinquent tax rolls are public record, they are also a direct target list for predatory investors and, in some cases, outright scammers, who monitor these lists specifically looking for homeowners in financial distress, sometimes offering to buy a property at a steep discount using the threat of an impending tax foreclosure as leverage, or falsely claiming to represent the county itself. If you are contacted by someone claiming to be able to resolve your delinquent tax status, verify their identity and any claimed government affiliation directly through your county treasurer's office before providing any payment or signing anything, since a genuine county office will never require payment through an unusual or urgent-feeling channel, and a legitimate resolution to a delinquent tax situation always runs directly through your county's own official payment process, not through a third party inserting themselves into that relationship. Step back and look at the actual practical shape of this story. The list itself is not new, not secret, and not something introduced by this year's Supreme Court ruling. It has existed in some form in nearly every American county for as long as property taxes have existed. What changed this year is the size of the safety net waiting at the far end of that list if prevention fails, now measured against an auction price that is frequently well below a home's real value rather than against the home's true worth, exactly the gap the Pung family's own case illustrated in painfully concrete dollar terms. That shift does not create new risk out of nothing. It simply makes the existing risk, the one that has always been sitting quietly in a public record, most homeowners never think to check, meaningfully more consequential if it is allowed to run its full course. If this helped you understand a real practical process worth actually checking on rather than a vague warning with nothing behind it, hit like so it reaches other homeowners who have never thought to look up their own county's delinquent tax roll, and subscribe if you have not, because I will keep tracking how states respond to this year's ruling, including any new legislative protections some states may add specifically, because Pung narrowed the federal floor. Tell me in the comments whether you have ever actually checked your own county's delinquent tax records, because that tells me exactly how much of a step-by-step walkthrough to build into a follow-up video on this exact process.